The H1B Guy here, and today the H1B Guy is going to cover the US Citizenship Act of 2021, discussing the impact of employment-based benefits. But before we get started, I'd like to ask you, if you haven't already, to please subscribe to the H1B Guy channel here on YouTube and like this video so that I can continue to produce more content like this for you. I also wanted to mention the H1B Guy offers a variety of consulting services. I help businesses and individuals solve complex work authorization issues in the recruitment process while bringing awareness to employment-based immigration benefits. If I can help you, please reach out. I'd love to hear how. Today's post is brought to you by RecruiterNetworks.com, the smart solution for digital perm ads since 2001. I'm going to cover subtitles C and D from the US Citizenship Act of 2021 text that Senator Menendez released on Thursday, February 18th, 2021. Starting with Subtitle C, Diversity Immigrants, Section 3301, Increasing Diversity Visas. Basically, they are increasing DV visas, the annual allotment, from 55,000 to 80,000. You know, this is a pretty big one. I mean, you're talking about 25,000 annual increase in green cards for diversity visas. It's not something to pass over. DV winners bring a very unique benefit to the U.S. economy. In many cases, they are willing to perform roles that Native Americans would never even consider. I do think that this is a significant increase, but I also think we may see this number reduced either to 70 or 75,000. Moving on to Subtitle D, reforming employment-based immigration, Section 3401, doctoral STEM graduates from accredited United States universities. This is basically awarding PhDs in STEM from U.S. institutions. They will no longer be counted against employment-based numbers. It does not account for medical degrees, which I've found pretty interesting. If you look at patent data, and there's a lot of data out there around patents from immigrants versus Native Americans, but the numbers are pretty staggering in favor of immigrants. We cannot restrict the path to permanent residency for the highest level of STEM education awarded in this country for employers who need the resources. Section 3402, addressing visa backlogs. Non-citizens who are beneficiaries, including derivative beneficiaries of an approved immigrant petition bearing a priority date that is more than 10 years before the non-citizen's application for admission as an immigrant or for adjustment of status, effective 60 days after the date of this enactment. Anyone with a priority date that is 10 years or more, 60 days from the date of the enactment, and their dependents will become current and able to file their adjustment of status. I'm guessing that would be somewhere in the range of 750,000 individuals who would fall in that category based on the I-140 approval numbers over the last 10 years, which we've covered here on this channel. Moving on to Section 3403, eliminating employment-based per-country caps. This strikes employment-based country caps effective beginning in fiscal year 2022. Pretty aggressive considering that date is October 1st of 2021. But this does come with a bit of an asterisk. Special rules for countries at ceiling. If the total number of immigrant visas made available to natives of any single foreign state or dependent area is expected to exceed the numerical limitation in any fiscal year, immigrant visas to natives of that state or area shall be allocated to the extent practicable and otherwise consistent proportion of the visa numbers made available and equal to the ratio of the total number of visas made available. Wow, so this basically is increasing the overall percentage ratio. I've seen some estimates out there that say this is increasing the percentage up to a 20% cap. I'm sure we'll get more clarification on this in the future, but this is kind of ambiguous in terms of the ratio language. Section 3404, increased immigrant visas for other workers. This is adding an additional allotment of 30,000 EB3 visas. This and the DV increase has Senator Durbin written all over it. These increases to EB green card allotment go from 140,000 currently to 170,000, but it's only applied to the EB3 category, meaning that 30,000 increase is only applied to the EB3 category. Section 3405, flexible adjustments to employment-based immigrant visa program. This gives DHS and DOL the ability to limit employment-based categories in EB2 and EB3 in specific geographic areas due to regional economic conditions. I'm hopeful that they will define the parameters that would allow them to make this adjustment. Giving DHS and DOL the power to limit allocation without a clear definition of the factors is a very scary proposition. Section 3406, Regional Economic Development Immigrant Visa Pilot Program. This creates the RED, Regional Economic Development Visa, with an allotment of up to 10,000 each fiscal year for specialized needs in specific geographic areas, requiring a labor condition application, and it will not be counted against employment-based categories. And just like that, a new visa category is proposed. Ladies and gentlemen, I present to you the RED visa. It's going to be very interesting to see how this plays out. The implementation of a new visa is no small feat. I will say, though, this is exciting because it has a high merit and skill slant to it. If implemented correctly, it could be the beginning of a shift to a true merit system. Section 3407, wage-based consideration of temporary workers. This keeps the door open for DHS to implement a wage-based selection for the H1B lottery. I've covered this a good bit. I still believe wage-based selection for the H1B lottery is a positive change to the current system, but I've also realized that something more of a hybrid selection process is probably more realistic. DHS has until December 31st, 2021 to announce their plans for the H1B lottery for fiscal year 2023. It's going to be very interesting to see what they do decide to roll out. Section 3408, clarifying dual intent for post-secondary students. Exactly what it says. Full-time enrolled F1 is considered dual intent for permanent residency. This is one of the worst kept secrets that is finally going to change. Section 3409, H4 visa program, eliminates aging out for H4 dependent kids, what we refer to here as documented dreamers or legal childhood arrivals based on their arrival age, 18 or less at the time. Creates immediate work authorization for spouses and dependents under the H4 EAD. Finally, some reprieve for documented dreamers, specifically H4 dependents, but the immediate work authorization is huge. Not having to wait until their spouse has an approved I-140 is a total game changer for high-skilled immigrant families and an instant injection in human capital into our society. Several have asked if H4 would qualify for LPI status, which is mentioned at the very beginning of the text. I don't believe they will, but I will wait until the legal experts solve that riddle. Section 3410, extensions related to pending petitions. F, H1B, L, or O visas may extend their status in PERM if it's been pending for a year, and it also may be extended in 1-year increments. Another big one, especially considering the massive delays we've been seeing in processing across the board. There is a lot to be cautiously optimistic about when it comes to the text of the US Citizenship Act of 2021. This is a massive, comprehensive immigration reform bill that's going to take months and months to debate and amend. I'm very interested to see what smaller bills will be introduced that will use similar language that we've been given here in the USCA21 text. I believe we'll see many changes to employment-based immigration in the next few years. But I want to warn you that it feels like to me that the current administration is still prioritizing the undocumented immigrant issues first. Of course, I'll be covering every update possible on USCA 21 as it begins to make its way through. To read the full post, please check out the H1BGuy.com, and don't forget to sign up for the mailing list while you're there. A reminder that today's post was brought to you by RecruiterNetworks.com, the smart solution for digital perm ads since 2001. This national job board network provides recruitment websites in 1,024 major U.S. metro areas. Each local job board is its own portal and is a low-cost resource for immigration recruitment ads for all industries and professions with a flat price of $225 per ad regardless of which city you choose. RecruiterNetworks.com has been the #1 place for immigration attorneys, immigration ad agencies, and employers to meet the DOL requirements for the digital portion of the PERM advertisement rules. RecruiterNetworks.com. Tell them the H1B guy sent you. Just want to ask you again to like this video, subscribe to the H1B Guy channel here on YouTube, and click the bell for notifications so you're notified anytime we post new content here to this channel or go live like we will this Wednesday night at 9 p.m. for the H1B Guy and Friends Live. Please join us. If you've made it this far, I just want to say thank you for taking the time to watch my video. I really appreciate your support. The H1B Guy, your global source for all things H1B.